Hello, welcome. I am the loud little ducky. Today we're going to be going over Echard's pre-trial statements. I'm just going to run this video. That way it can go as quick as possible because there is a lot to go over. So let's jump right in. So we have Woodnick in the matters of Owens v. Echard in Superior Court of State of Arizona in and for the County of Maricopa, respondents' pretrial statements assigned to the Honorable Judge Matta. Evidentiary hearing is scheduled for June 10, 2024 at 8:45 a.m. So respondent/defendant Clayton Echard hereby provides this pretrial statement for the evidentiary hearing scheduled for June 10, 2024 at 8:45 a.m. This proceeding is not complicated, but it is certainly unique given the fraud and the circus-style antics from the petitioner/plaintiff, Laura Owens. Laura, who seems unburdened by both science and societal expectations of truth, filed an improper establishment petition and order of protection predicated on faked medical records after being rejected by Clayton Echard. Laura's medical records, arts and craft skills have been honed over a decade, where she falsified records to support fabricated twin pregnancies, forged ultrasounds, manufactured HCG reports, faked ovarian cancer, and feigned having an oophorectomy, which is an ovary removal. She cannot claim that she lacked the intent to commit fraud upon this court when she filed these actions after oral and then appeared in court twice donning what appeared to be a fake moon bump. Laura's malignancy was exposed because she targeted Clayton, the former ABC's bachelor, as her fourth mark. Clayton immediately disputed the pregnancy, causing Laura to utilize her playbook alleging twins, crafting dating contracts, offering abortions, claiming suicidality, and alleging that she was the victim of SA. Laura also contacted the media, see footnote 1. In addition to Laura contacting The Sun, Page 6, and People, her counsel has made comments about looking forward to reading the obituaries of reporters and about making them homeless, ostensibly consistent with how Conor McGregor would act if he was litigating this case. Oh, so poetic and beautiful, Woodnick. So Laura also contacted the media, which resulted in 3 prior victims of the same pregnancy connecting. What Laura failed to consider was that her claims of being 24 weeks pregnant with twins and vague miscarriage allegations, including suggestions that twins were reabsorbed into her body, would result in the media she contacted comparing her to known fraudsters like Scamanda. Oh, brought Scamanda into this. As if unable to stop, Laura continued to commit fraud, including misleading her own medical expert, who, impressively and contrary to science, appears to have determined paternity without DNA testing. By failing to tell him about her medical history or faked history, including but not limited to ovarian cancer and oophorectomy, as well as the fabrication of the sonogram he received, and perhaps even the July 23rd miscarriage photos. Laura's attempt to prevent a full and fair adjudication have only escalated as, through counsel, she, per witness Michael Maraschini, suggested a witness would be arrested if he appeared at court for this trial. Further efforts to embarrass Mr. Maraschini's involved Laura's. Let's see what else. Further embarrassment of Mr. Maraschini. Laura's counsel posting a California deposition transcript from 2018 online. She, through counsel, even tweeted commentary about the case and this court. See footnote 2, tweeting on or about May 26, 2024, that Clayton's counsel wanted to inflame and bias the judge, and it seems to have worked. See YouTube video. Clayton implies he wanted to have sex, but Laura didn't. Then see YouTube video, taking pregnancy test at Clayton's apartment. Yeah. I don't like those bits of Clayton's deposition that he posted. They didn't do Laura any favors. It's consistent with what Clayton has said. His story has never changed. He doesn't have to keep remembering things because he's just saying what happened, and that's why his is consistent. She even mocked Dr. Dean's expertise and expert report and then published it online. On May 28, 2024, Laura and her counsel published a joint blog post in which Laura made overt claims of suicidality and appears to admit the 2,500 pages of text with Maraschini were legitimate, and that she never received an ultrasound for her alleged twin pregnancy. Days later, Laura, through counsel, posted parts of a video deposition of Clayton Echard on YouTube, which we went over those. The level of inappropriate behavior in this matter is astounding. Laura's anticipated crocodile tears and claims to have been the victim of the media who exposed her cons are disingenuous. Laura's behavior should result in findings from the court in the two causes and may justify a referral to the Maricopa County Attorney for charges of both perjury and evidence tampering. See ARS 132702 and 132809. We will take a look into both of those. Background. Number 1. On August 1st, 2023, Laura initiated litigation when she filed her petition to establish paternity, legal decision-making, parenting time, and child support, alleging that she became pregnant with respondent's twins. On May 20th, 2023. On August 8th, 2023, Laura filed a denied motion to communicate, and on August 23rd, 2023, a denied motion to compel. On August 29th, 2023, Laura filed a denied expedited consideration request, motion to communicate, and on September 14th, 2023, a denied expedited motion to seal court records. Denied, 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 denied. Sit down. 3. On August 21st, 2023, Clayton, representing himself, filed his answer denying any pregnancy with twins after only oral. See footnote 4. Laura's involving tale regarding May 20th, 2023 has changed during the litigation and now includes an ARPing insinuation. In messages to Clayton, an effort to force a dating contract, Laura acknowledges there was no intercourse and offered that her vajiji is tight after not having sex in more than a year, but then claimed some of his fluids were down there, and that I don't know the difference between the types of cum, ellipses. I could have really just not needed to ever read that statement in my life. It was not until 2024 that she alleged she was ARPed, after first alleging that Clayton was too high to remember having intercourse, insinuating she had taken advantage of him. I have never heard of someone being too high to remember. It's not certain drugs. It's not drinking and passing out. It's weed or weed gummy. Like, I don't know. It makes no sense to me, but maybe. See also respondents granted motion for leave to amend response, filed December 12th, 2023, and respondents amended response to petition to establish, filed January 26, 2024. So many filings. Number 4. On September 28, 2023, through an early resolution conference, parties entered a Rule 69 agreement stating petitioners agree to contribute a sample on October 2nd, 2023, to determine paternity of alleged pregnancy. Testing to be conducted by Rabgen. Number 5, on October 6, 2023, Laura filed for an ex parte order of protection with the claim number, claiming that she was pregnant by Clayton and that she was cyberbullying that he was cyberbullying her by posting her medical records online. That same day, the RabGen results came back indicating little to no fetal DNA. And Clayton thought the nightmare was over. He was very wrong. Oh, was he? The nightmare was just beginning. Number 6, on October 18th, 2023, Laura filed a request for a pre-decree mediation, denied on November 22nd, 2023, alleging Clayton would not speak to her, and he even acts as if the unborn children don't exist despite a preponderance of evidentiary. 7. On October 24th, 2023, Laura appeared by video before Judge G, wearing what appears to be a fake pregnancy stomach, moon belly. She was also photographed on September 27th, 2023, competing in a horse jumping competition with a visibly flat stomach, and was signed up to compete in late November 2023, but allegedly backed out after attempting to sign up under a different name. 8. On October 25th, 2023, Laura appeared before Judge Duty, again wearing what appears to be a moon belly, and testified as to the veracity of a sonogram of their son, which she has since claimed no knowledge of, but that she sent to both Clayton and the media, as well as including her publicly accessible Dropbox on Reddit. See also respondent's motion for relief from judgment filed March 26, 2024. Number 9. On November 2nd, the second day of trial on Clayton's granted injunction against harassment, Laura testified that she was 100% and 24 weeks pregnant by Clayton, and that she was due February 14th, 2024. Must I say, thank you for filling in the October gaps. Because we know stuff happened in October, even though Owens' side just likes to forget that October even happened. Laura further specifically detailed she was experiencing a high-risk pregnancy due to her alleged epilepsy. I like how I put alleged epilepsy. Like, maybe she's faking that too. Which, you never know with her. I don't know. I don't know why she has so many. She does have a lot of epilepsy medical records, so I don't know. And that she was being seen by a specialist, Dr. McCool, and Dr. Higley, who Owens likes to forget to mention. And that she had an appointment with Dr. Higley last Friday. After this court's order, Laura complied with disclosure. She had refused to comply with Rule 49. It was confirmed that Laura's testimony was false and that she was never treated by Dr. McCool, Higley, or any obstetrician or gynecologist during her alleged high-risk pregnancy with twins. See footnote 5. Laura self-reported to her neurologist via video while in the seated position that she was 21 weeks pregnant with twins. Laura also told the provider that she saw for the first time on November 14, 2023, MomDoc, that she had been pregnant. The pregnancy had been confirmed by Planned Parenthood, that she passed 2 sacs, and that she had been told her blood HCG levels were not consistent with a viable pregnancy. There was no sonogram at Planned Parenthood, and if the latter statement bears any truth, this means Laura was told she was not pregnant before she testified in front of Judges Duty, G, and this court. So in front of Judge Duty, Judge G, and Judge Mata. She knew about all this. Nope, we can't go to number 10 yet. Oh, yes, we can go to number 10. So, on December 6, 2023, results of yet another RabGen test confirmed little to no fetal DNA. Again, Clayton thought the nightmare was over. He was wrong again. Note, the second Ravgen test was allegedly lost in transit. So that's 2 tests. Actually, 3 tests so far. We've got the first, little to no. We've got the lost one, and then we've got another one with little to no. So 3 tests so far. On December 12th, 2023, Clayton filed a notice of filing affidavit of non-paternity, avowing that he could not be the father to any children from Laura as they never had sexual intercourse. Clayton also filed his granted expedited motion for extended dismissal date on inactive calendar and scheduled an evidentiary hearing. Number 12. On December 28th, 2023, Laura filed her denied, see footnote 6. Although the court's minute entry dated January 25th, 2024 does suggest that Laura's motion to dismiss was granted but maintained as the issue of sanctions and attorney's fees remain. The court's minute entry dated February 21st, 2024 and discussion in court clarifies that the court was denying petitioner's motion to dismiss petition to establish. So, 28th, Laura filed her denied motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice, as well as a notice requiring strict compliance with Arizona Rules of Evidence, which invoked Rule 2A, Arizona Rules of Family Law Procedure. For the first time, Laura's motion cryptically claimed that she is now not pregnant. 13. The same day, Clayton notified Laura of his intent to depose her pursuant to Rule 57A1 and requested the production of documents pursuant to Rule 62. So how convenient is it that on the day he wants to depose her and he wants her documents, she files that, oh yeah, I'm not pregnant anymore. 14. On January 2nd, 2024, Laura filed a denied expedited motion to quash deposition of petitioner. Laura's counsel, her first of 3 attorneys, withdrew. 3 attorneys in this case. 15. On January 3rd, 2024, Clayton filed a response/objection to petitioner's motion to dismiss. See footnote 7. For brevity, this background summary excludes all other responses and replies filed in this matter, as well as a withdrawn motion for sanctions pursuant to Rule 26. So Gingras is on the case as of now. And this is the withdrawn motion for sanctions and a response/objection to petitioner's motion to dismiss. Number 16. On January 17th, 2024, Clayton filed a notice of non-appearance at deposition pursuant to Rule 57G, notifying the court that Laura willfully failed to appear at her deposition and requesting attorney's fee pursuant to Rule 57G. 17. On January 18th, 2024, Laura, with her second counsel, filed a denied motion for confidentiality and preliminary protective order, claiming for the first time that Laura had a miscarriage. Notably, no other information about the alleged miscarriage was provided. 18. On February 2nd, 2024, Clayton was deposed by Laura. See footnote 8. Pursuant to Rule 59C2, Clayton intends on offering his deposition against Laura, including discussion of ultrasound. Laura has admitted to altering and presented as an exhibit, as well as the ultrasound video on pages 42, 44, 46, 63, 90, 91, 111, and 122, or 111 through 122. On February 6, 2024, respondent filed granted expedited motion to continue trial and motion for additional trial time. 20, on February 12, 2024, respondent filed a granted expedited motion to set virtual status conference. The court scheduled an in-person status conference for February 21st, 2024. 21, at this conference on February 21st, 2024, the court addressed petitioner's failure to comply with Rule 49. See attorney's fees below. Petitioner claimed that she had a miscarriage sometime in September or October, which is way different than July or November. This is why this miscarriage is such a hot button thing, because it could have been any month. It also could be none of the months, because it never happened. The court indicated it would hear evidence and testimony as it applies to all pleadings filed within the Maricopa County Superior Court, and it would be viewing the order of harassment hearings. So Judge Matta was supposed to go and watch that moon bump hearing, the order of harassment hearing, which was done in 2 parts. But only the first part did she have her belly on camera. The second one, she sat her butt down for. 22. On March 1st, 2024, Laura was deposed, and it was discovered that there was yet another pregnancy fraud allegation, number 4, from 2014 in San Francisco. Clayton intends to offer the entire deposition, see footnote 9, specifically pages 1 through 175. Line numbers would be unhelpful, as parts of the entire deposition will be utilized as evidence against Laura. Okay. All right. So Clayton intends to offer the entire deposition as evidence against Laura, consistent with Rule 59C2. 23. On March 11, 2024, respondent filed a granted motion to compel. On March 12, 2024, petitioner's third attorney withdrew. Okay, so January Gingras hadn't been on the case. That was the time period right before Corey Keith came on. Then Corey Keith came on for the deposition, and then he withdrew on March 12th, 2024. All right. Now, on March 25th, 2024, respondent filed a granted motion for joint hearing and granted in part, see footnote 10. Okay. In the court's minute entry dated 5/22/2024, the court clarified that it would be viewing the order of protection hearing before Judge Duty and referring ruling on the motion pending the trial. I don't know why he has that footnote in there twice, but he does. So not only is she going to go back and watch Clayton's order of harassment hearings, she's now going to go back and watch the Judge Duty with the Halloween costume and that picture that she says only Clayton had, which was a lie. So granted in part, motion for relief from judgment, which was amended on April 26, 2024. Number 25, on April 1st, petitioner's third attorney filed a denied motion for extension of time to respond to respondent's motion to compel and a declaration of David S. Gingras in support of petitioner Laura Owens' motion for extension of time to respond to respondent's motion to compel. So he was denied right out the gate. We know you just got here, but we're not continuing this case. We're not giving any extra time. You need to come on in and catch up. And I think he was given plenty of information to be able to catch up. He should have stayed off of Twitter and focused on his file folders. Number 26, on April 3rd, 2024, respondent filed a granted motion to withdraw motion for sanctions pursuant to Rule 26. Petitioner filed a notice of non-objection on April 4th, 2024. On April 8th, petitioner filed a denied motion to compel lunch and for alternative relief. On April 12th, petitioner filed a granted request for judicial notice, requesting this court take notice of petitioner's case against Gillespie. See footnote 11. Mr. Gillespie is expected to testify that he experienced twin pregnancy fraud by Laura after rejecting her and as addressed by Judge Bacchus and Gordon, and which involved a fake sonogram. So they asked for a judge to take judicial notice, and she took judicial notice of that fact in the Greg Gillespie case. So she knows about Gillespie. She knows all of this hogwash that Owens has tried to feed everyone, and that Gingras has tried to feed everyone. We're not buying it. 29. On April 30th, 2024, petitioner filed a denied emergency motion to strike and a request for immediate telephonic scheduling conference and denied motion in limine, attempting to preclude testimony from the three men who anticipated to testify that Laura fabricated pregnancies, medical records, cancers, oophorectomies, to force unrequited relationships. On May 10th, 2024, the petitioner filed a denied motion for judgment on the pleadings and renewed motion to dismiss. And on May 13th, 2024, a notice of non-availability and notice of errata. We did not go over those two things because they don't really matter to this in the main meat of the case. 31. On May 21st, 2024, respondent filed a stipulated motion for virtual appearance of witness Dr. Deans, MD. So that right there is a good timeline as far as filings and everything else that has happened in this case. Now, for part 2 of this, we're going to go over contested issues. So the first one in contested issues is non-paternity. This court should find that Clayton was not responsible for any alleged pregnancy. That Laura will claim she believed she was pregnant from oral is farcical, yes, and not the legal standard. Even if that was the standard, it is indisputable that Laura did not have any basis to believe she was pregnant with twins, as she alleged in her petition, because she faked the sonogram records. She never sought OBGYN care. She never had an ultrasound, and she lied to the court about her high-risk pregnancy with twins. See footnote 12. Oh, I think we missed part of... Okay, so that last footnote about Greg, where it was like, you should take judicial notice of, the Greg Gillespie and the fraud pregnancy of twins and stuff. The rest of that is that Laura purchased, it is a watermarked Fiverr, a website where you can ostensibly hire people to Photoshop images. So that has been put on judicial notice and granted. The judge granted that judicial notice. She took it on. So now let's go to the things that she lied about in this non-paternity, the footnote 12. Before Judge G, on November 2nd, 2023, Laura testified to having a high-risk pregnancy with boy and girl twins, being 100% and 24 weeks pregnant, and to being seen by Dr. Higley and McCool. Laura admitted as an exhibit a screenshot of her making an appointment with Dr. McCool, which the lawyer in that hearing, that woman attorney, the way she just crossed Laura was beautiful. So you made an appointment. That's all you made. Well, no, I was seeing him. That's why I took a picture of it. You can't just make an appointment. I sent records over. So the exhibit of the screenshot of her with making the appointment with Dr. McCool. Laura has since testified that she never received care from any pregnancy provider or specialists. So she's admitted. So she lied about all of those people. Contested issue number 2. Alleged pregnancy. Pregnancy is caused by sex, not relationship cons. Laura and Clayton did not have P to the V sex. Laura's allegations about what happened that night have morphed over time in order to fit Laura's narratives as she is confronted with science and the significant holes in her story. Laura has claimed there were fluids down there. Then claimed Clayton was too high to remember having intercourse. Then claimed Clayton ARPed her. See footnote 13. 13 says, curiously, in her underlying petition to establish, Laura stated that there was no domestic violence and requested joint legal decision-making and a holiday schedule. As the essay allegation did not arise until after Laura realized Clayton, like others, had zero interest in a relationship and that he was questioning her twin pregnancy narrative. So she even checked on her paperwork that no domestic violence, no essay happened with her. And then she goes and changes it because she needs people to feel bad for her. She needs people to believe her. Oh, she just didn't want to get him in trouble. Sorry. You came out with that information. And we know you don't have a problem. You know, oh, I was afraid to come forward. I didn't want to get him in trouble. No, you weren't. Because you've come forward with this allegation for every single man you've been with in the last 10 years, it seems like. So I'm not buying that she just didn't mention it. Laura even sent an email admitting they did not have sex and essentially begging Clayton to have sex with her for the first time because she was tight and had not had sex in years. See footnote 14. Note, with Gillespie, Laura also claimed she had not had sex in years. She later, with Gillespie, concocted a disturbing story that Gillespie and his counsel, undersigned, were involved in her kidnapping and ARP, and that it was being investigated by the FBI in an ex parte letter to Judge Bacchus. Yeah, that Gillespie and Woodnecht were involved in her kidnapping and ARPing. And we wonder why Woodnecht is as fed up and pushing this case as much as Clayton, Gillespie, Maraschini, and Matt. Because Woodnecht is also another one of her victims as far as false allegations. This is not something to, pardon my language, to fuck around with. She needs to be in jail. Laura's only proof of pregnancy is one urine HCG, see footnote 15, test conducted at Banner on June 1st, 2023, one blood HCG test on October 16, 2023 that indicated levels of HCG that by Laura's own admission are inconsistent with pregnancy. See footnote 16. So, footnote 15 is HCG tests are not dispositive of pregnancy. As Dr. Deans will confirm, HCG can be present in an individual for reasons unrelated to pregnancy. I proved that with myself last week. So that is true. Dr. Deans is right, according to my own personal medical research and experience, including medications for epilepsy and fertility treatments, as well as if the person injects themselves with HCG. And by God, I hope she didn't inject herself with the horse HCG. Because what in the hell? Like, we know she's crazy, but by God, that's crazy if she's putting horse stuff in her. She wouldn't be the first. And I don't know if it's dangerous or not. But, I don't know. You shouldn't be putting things in your body without consulting a doctor. Footnote 16, Laura also alleged that she lost 30 pounds and that is somehow proof of pregnancy, or that her body absorbed 24 to 28-week fetuses, all while competing in horse jumping competitions. Per her records on June 1st, 2023, Laura weighed 121.25 pounds. On November 14th, she weighed 133 pounds. And now she's at 91 pounds, according to her scale that has been photoshopped, that I truly believe has been photoshopped. Oh, good God. All right. Laura's only. Okay, we already went through Laura's only proof of pregnancy. Okay, note, even her October 16th, 2023 HCG test provided to her expert is dubious, as Laura, through counsel, has admitted to sending an altered version with 102,000 HCG, 1,000 times higher levels to the media. Laura fabricated a medical record while simultaneously refusing to cooperate with Rule 49 disclosure. So the media in this, with that HCG, I don't know who else she sent it to, but we know that Dave Neal got a copy, I believe Reality Steve did, but they're a part of the media that received some of this documentation. It's just so crazy. So she was not following her obligations in the order to compel. It says Laura is guilty of both copious perjury and evidence tampering, warranting this court endorsing the Maricopa County Attorney's Office. Contested issue 3. Alleged sonograms. Laura faked the sonograms, at least 3 with Clayton. And there are so many more that aren't with Clayton's case. It says there are no verifiable and requisite sonograms to support Laura's claims of being pregnant with boy and girl twins after oral sex. See footnote 17. Per Dr. Deans, an ultrasound provider may be able to determine a possible twin gestation, not gender, no earlier than 7 weeks gestation during an ultrasound. The only sonogram Laura states is hers indicates a gestational weeks of 6 weeks, 4 days. Parenthetically, the gestational age on the doctor's sonogram, if obtained on 7/2, would be consistent with the conception date of June 2nd, 2023, not May 20th, 2023. Sexes would not be discernible until around 16 weeks. Laura texted Clayton, "We are having boy and girl twins." Or we are having a boy and a girl, and I have an ultrasound to show you, and they dated it literally exactly to when we were together. Which, as we know, is not how they put things on the sonogram. It's just not. There was no date of the sex incident on any of my grandson's stuff. Nothing. My daughter didn't even have to disclose the day she had sex. I mean, we knew, but like it was not in any of that stuff. All right, let's go back up here. On October 25th, 2023, Laura testified before Judge Duty to getting a sonogram of their son and providing it to Clayton because she was concerned about the baby's profile, whom she accused of using it to make an online Halloween meme, which he vehemently denies. Laura also admitted an exhibit, see footnote 18, where she tells Clayton that she has a sonogram video dated September 5th, 2023. So footnote 18 says Laura's Exhibit 6, an email from Laura to Clayton, was admitted during the order of protection hearing before Judge Duty in the case number. On February 2nd, 2024, Laura used doctored sonogram as an exhibit during her deposition of Clayton. On March 1st, 2024, Laura testified to obtaining the same sonogram anonymously at Planned Parenthood Mission Viejo on July 7th, 2023, and falsely and illegally, gotta put that in there, illegally attributing it to Southwest Medical Imaging, also known as SMILE, and that she found out she was pregnant with twins in July. So 2 months pregnant, she knows not only that she has twins, but she knows that they're boy and girl twins by 2 months pregnant. Get the F out of here with that shit. No. So we go to footnote 19. Planned Parenthood confirmed they do not offer anonymous appointments. On or about April 15th, 2024, Laura then claimed the appointment date was July 2nd, 2023, and that she was seen at Planned Parenthood in Costa Mesa. So now it's Costa Mesa Planned Parenthood. She probably had to call around and find one that would do anonymous. But from my understanding, none of them do them anonymous. They can be anonymous to other people, but you can't come in there anonymously because they have to have bookkeeping of people that go into that place. They would be shut down so fast if they were doing things and nothing was documented. That would be illegal practice. So she lied in her deposition saying it was Mission Viejo. Now she's correcting it to a different day because she lied about the day and the place. Now she's correcting it to say it's on July 2nd and it was Costa Mesa Planned Parenthood. Both SMILE, Southwest Medical Imaging, and Planned Parenthood have confirmed Laura was never seen there for an ultrasound. Planned Parenthood further confirmed that the alleged July sonogram is not consistent with ultrasound images generated by their practice. So whatever image this is, they didn't do it, and it doesn't look like any image that comes out of their facility. Still, Laura signed an affidavit for her expert that included the fake sonogram and stated this image was taken at Planned Parenthood. Emphasis in original. No evidence supports Laura ever being seen by any provider for an ultrasound. As this court noted in its May 22nd, 2024 minute entry stating, neither Planned Parenthood in Mission Viejo nor SMILE have any records for any ultrasound appointment for plaintiff. Yes, when she put out that thing, she said, I understand this. These are the things that I understand because she has seen these things. as she's making her judgments, she's seen those forms that state, nope, because Woodnick has put him in as exhibits in his filings. Another contested issue is alleged miscarriage. Laura was never pregnant by Clayton. Could not have miscarried Clayton's twins. Laura's miscarriage tales now apparently dated July 23rd, not September, October, not November, not December, July 23rd, only arose after she was confronted by Clayton's desire to prevent her from getting away with her extreme pregnancy fraud con and exploiting another TED Talk or chicken soup essay. This included Clayton notifying Laura he had contacted the putative father registry to prevent Laura from claiming she put the twins up for pretend adoption as a means of explaining their non-existence. Which I'm glad that there is such a thing as punitive father registry. That is really cool. That dads who think maybe their kid is going to be put up or is put up for adoption can go in there and register. And if for some reason somebody tries to put that particular man's kids up for adoption, or they are in there, that the biological fathers, of course after DNA testing and stuff, can be notified. Because as we talk about so much, that sadly the men, they can have their opinions and they can say whatever they want about things that they want to happen with the baby, whether they want to keep it, whether they want it aborted, whether they want it put up for abortion, all of that. Or whether the woman lies and said it died when it didn't, all these different things that women can just say and do to guys. And they really don't have a choice. I've heard stories of men who are like, she didn't even tell me about the pregnancy before she got rid of it, because I would have taken the baby. She didn't even give me a chance to raise my own kid. She put it up for adoption without even telling me she was pregnant. She raised a kid without ever telling me she even had one that was mine. They show up on the dad's doorstep at 18 being like, I think you're my father and I'm your daughter or I'm your son. These men don't get a say because the pregnancy and the babies are in our bodies. And until they come out of our bodies, the fathers have nothing. They have no rights. Unless there's some prenatal paternity thing done, but a lot of people don't do that. Because normal folks don't have the money to go spend that. So men have nothing when it comes to these babies because they are in the woman's body and it is the woman's choice. Thankfully, there are plenty of amazing women out there that do let the fathers have a say, and they talk to them about it, and they actually listen, and they come up with a plan together. But not all women are like that. Laura tries to act like she's that kind of woman, and she's not. But you really have to feel for some of these guys. Yeah, there's a bunch of deadbeat dads, okay? But I'm talking about the ones that actually want to be there for their children. So the fact that this punitive father registry thing is available for people is amazing, because that did not exist a long time ago. So at least that's something for the guys. It's just one other thing that the guys have going in their favor for the ones that truly would want to be a father to a child that was theirs. Whether they liked the person of the mother or not, they want to be there for their kids. So that is amazing. Sorry, I went a little off there, but we just need to highlight that. So Clayton registered for this so that he would be notified if Owens tried to put twins up for adoption if they were real. We knew they weren't, but just in case. And so that if she did say that, they can be like, no, there were no babies put up by anybody with this DNA. Nothing like that ever happened. So amazing that Woodnick even thought about this, or Clayton even found out about this. Amazing. All after testifying she was 24 weeks, actively being seen for high-risk pregnancy and due in February. Meanwhile, Laura continued to post on Reddit, published various blogs on Medium, portraying herself as a victim, and contacted the media to advance her fictitious narrative. This is not the first time Laura has feigned a miscarriage or leveraged offers to terminate pregnancy in exchange to the victim agreeing to date her. With Michael Maraschini in 2016, Laura alleged she was pregnant with his twins. See footnote 20. Clayton disclosed 2,500 pages of text messages between Michael Maraschini and Laura. In light of Laura's repeated claims that her victims, including Michael, have fabricated or tampered with communications, a computer forensic expert, Mr. John Berryhill, assessed the metadata and confirmed that there was no tampering from Maraschini. What is there is what happened, whether Owens admits to it or not. Those things were sent from Laura to Maraschini. Maraschini didn't do anything with all this stuff. This confirmed that Laura historically claimed she had, we got to go to the footnote and over to the other page to finish those sentences. So the ovarian cancer, and she had an ovary removed in addition to alleging she was pregnant with twins, had a miscarriage, and a severe allergic reaction to an abortion drug, and that only one of the fetuses was terminated via abortion, which she told Gillespie. Yeah, she's allergic to these abortion drugs, severely allergic, but yet she keeps seeking them out. Make it make sense. So she was talking about she had a miscarriage, and that after speaking with providers, she knew what to look for to determine whether she was miscarrying. With Gillespie, it was offering to abort the twins if he agreed to date her. With Clayton, Laura alleged for the first time that she miscarried when she requested a protective order on January 18, 2024. On November 14, 2023, Laura self-reported to MomDoc, a provider she had never seen before, that she passed 2 sacs which appeared to have membrane but denies having much bleeding. During the status conference on February 21, 2024, Laura told this court she miscarried sometime in September or October 2023. Days later at her deposition on March 1, 2024, Laura testified that in September or October she passed 2 sacs that were less than the size of her hand. So good on Woodnick for putting less than the size of her hand in this document. He corrected himself. That she took a picture of them and sent it to an online provider. And then we've got footnotes 21 and 22 to go over. Laura also was engaging in repeated communication with Clayton and the media, referring to sonograms and videos that showed she was still pregnant, in addition to testifying before 2 judges in late October, early November, being 100% in 24 weeks. Woodnick is going to hammer this 100% 24 weeks. He is going to hammer that in all of this. And then footnote 22 is there is no record indicating Laura showed any provider these alleged 2 sacks. So we don't have any medical records that say that they received or saw these sacks. On April 8th, 2024, Laura, via counsel, stated that she passed the 2 sacks on July 23rd, 2023. So now, they're not September, October sacks. They're July 23rd sacks. That's a big time gap. Before Laura filed the underlying petition of her order of protection and before she testified before 3 different judges about her feigned pregnancy, Clayton's experts have reviewed the images, which may be fake, but even assuming they are real. And Dr. Deans will testify that there is no obvious embryonic or fetal tissue, which is complicated by the theory that Laura would have been miscarrying twins that were 8 to 11 weeks and would have experienced significant bleeding. Note, Laura refused to provide her phone number to a forensic expert to confirm the image's authenticity, which is highly dubious given her admitted history of fabricating records. She won't let those photos be authenticated. Why, if they're real? Because they're not. That's why. They're not hers. They didn't come off of her phone. Or they've been doctored for what they originally were. Wouldn't you want a forensic expert to confirm the authenticity of those things? Wouldn't that help your case, Owens? Order of protection. The OOP against Echard must be dismissed because it was procured through intrinsic and extrinsic fraud by Laura. Clayton's position are well summarized by this court in its May 22nd, 2024 ruling and fully briefed in the motion for relief. The order was upheld by Judge Duty, who did not know the history of fraud. As a result of extrinsic and intrinsic fraud by Laura because she was never pregnant with his twins, and the ultrasound in the image Judge Duty found to uphold the order of protection was manufactured by Laura, who has since denied the image belongs to her, despite her sending it to Clayton and the media and including it in her public Dropbox on Reddit. Yeah, her lie for this is that she had a real ultrasound that she had labeled what that one was labeled. And then somehow this other image that with the same file name was sent. But that's not the one that she meant to send. She sent the one that she thought she saved, but then when it was shown, she was like, well, that's not the one that I saved on that file, so somebody must have hacked my computer. Bitch, please. No. Attorney's fees, sanctions, and referrals. This court has broad authority to assess the conduct of Owens throughout the 3 proceedings before the 3 different judges and to sanction Laura pursuant to ARS 25324, 25415, and 25809G. Laura ignored disclosure obligations for nearly 7 months, and it was not until this court compelled her cooperation that evidence of a 4th victim was revealed, or that she committed to her recent tale of miscarriage in July. But despite allegedly passing 2 fetuses less than the size of her hand, she allegedly did not know she had miscarried until November, and curiously did not inform Clayton or this court until January about the miscarriage. She said she wasn't pregnant anymore in December, which is still after November when she supposedly found out. Like a month after she found out. Because she went to Mom Doc on November 14th. It wasn't until December 28th that she filed that she was no longer pregnant. That should have been filed as soon as she found out. Then It wasn't until January that she said that she wasn't pregnant anymore due to a miscarriage. So she didn't even mention miscarriage in November or December. She only mentioned it in January. Laura's conduct cannot be accurately captured in the word unreasonable, as faking a twin pregnancy after oral doctoring and submitting medical records, threatening witnesses, committing continuous perjury deserves a word more befitting behavior beyond even the family court pale. Like, it is more than unreasonable, unjust, unfathomable of the shit she has pulled. In addition to the fraud underpinning the entire litigation, the court merely needs to read Laura's Medium articles, the tweets, and the blog posts to appreciate the scope of the damage she has caused, which, as recent as May 28, 2024, includes a joint blog, which we know about the joint blog post from Laura and her counsel, and YouTube postings of Clayton's video deposition. Clayton is entitled to all his reasonable fees and costs incurred pursuant to ARS 25-324. To date, Laura has provided no evidence to support that she was ever pregnant by Clayton and with Clayton's twins. Laura has refused every opportunity to resolve the matter outside of court in all efforts to comply with disclosure, including failure to appear at a scheduled deposition and not fully complying with the eventual order to compel. Recall, this entire saga was initiated by Laura going to the Sun and making false claims of pregnancy, ostensibly because Clayton rejected her. Laura's order of protection and the underlying petition were both filed in bad faith, as Laura knew that she was not and could not have been pregnant with Clayton's twins. Laura then proceeds to fabricate evidence, not for the first time, testify before 3 judges to being 100% and 24 weeks, there he is, putting that in there, with twins, see footnote 24, and file irrational and legal unsupported filings that continue to assert what Laura cannot prove, that she was pregnant with Clayton's twins. That is very well summarized. Let's go to these footnotes. Footnote 23, as witnesses Maraschini and Gillespie are expected to testify, Laura fabricated medical records, including sonograms in her pregnancy con with their fake twins. Footnote 24, at the same time as her claimed high-risk pregnancy, Laura was actively participating in a horse jumping competition with a visibly flat stomach, contrary to her very visible moon belly. Continuing on in the document, and it was more than just simple misstatements. Yeah, just a little minor perjury. As this is extrinsic and intrinsic fraud upon the court, encompassing false testimony, altering evidence, and using coercive threats to tamper with potential witnesses and extort Clayton. Laura, the day before her deposition on March 1st, sent Clayton a letter threatening to sue him for collateral allegation for around $1.4 million unless he agreed to dismiss this action. This overt, extortive effort is eerily similar to Laura's antics with Judge Bacchus in the Gillespie matter, where she maliciously claimed Gillespie and his counsel were involved in ARPing her in an attempt to avoid a hearing. Through her third counsel in this matter, Laura has intimidated witnesses, including suggesting Maraschini would be arrested if he appears to testify. Filed legally unsound filings designed to waste fees and delay trial. Sent overt threats and harassing communications to Clayton's counsel and members of the media. Engaged in toxic and inappropriate diatribe regarding this case through Twitter and blog postings, including posting derogatory terms, insinuating that any ruling in Clayton's favor would be a mistake and the judge was biased against Laura. And it appeared to intimidate Laura's own prior counsel into refraining from complying with his Rule 3.3 ethical obligations. which we will be going over some stuff about that little Rule 3.3 ethical obligation. Yes, we will. That video is to come next, thanks to Megan Fox. Please go subscribe to Megan Fox Writer on YouTube. Okay, Section 3, Witnesses. Respondents' witnesses. Number 1, Clayton Echard will testify to all issues. Number 2, Laura Owens will testify to all issues. 3, Michael Maraschini, former romantic partner of Laura, see response to motion eliminate. He is expected to testify regarding the origin of the 2,500 pages of messages with Laura from 2016 and 2017, where she made nearly identical claims involving fake twins, miscarriages, abortions, threatened suicidality, including claiming to be admitted into the mental hospital. Well, I don't know. Her mom and them say she was admitted into it and she was there. But then she, in her little declaration, I was not admitted into that like Michael Maraschini says I was in his declaration. See the Michael Maraschini playlist and his series with Laura for that drama. He is expected to also testify regarding the personal claims in Laura's recent affidavit, claiming he faked her medical records, which have been disproven by the forensic technology expert who verified that the medical records indicating ovarian cancer, ovary removal, were sent to him by Laura. So that is Michael Maraschini. So we got 3 witnesses. I like that we're getting a look at the witness list. Number 4 on the witness list, Gregory Gillespie, former romantic partner of Laura, see response to motion in limine. He is expected to testify that Laura fabricated being pregnant with twins, claimed she had an abortion several times, and repeatedly stated she would dismiss her lawsuit if he agreed to date her. Gillespie is expected to confirm that the sonogram of the twins sent to him by Laura was from Fiverr. He is also expected to testify in the response to Laura's allegations that he doctored her medical records because she said Gillespie hacked in and messed with her medical records. So, yeah. It's everybody else's fault but hers. She is seriously Amber Heard 2.0. Number 5. Dr. Samantha Deans, MD, will testify regarding her expert review of the medical records of Ms. Owens, including her analysis that the alleged HCG tests were never dispositive of pregnancy, and that the related miscarriage timeline, which includes detailed analysis of likely origin of HCG in petitioner's blood and urine, is not indicative of human gestational norms. Her testimony will also address the veracity of petitioner's miscarriage of 2 fetal sacs and alleged sonogram from Planned Parenthood. Number 6 on the witness list, Mr. John Berryhill. I think he's going to be testifying via Zoom. A forensic data expert will testify regarding his expert review of the personal computer of Michael Maraschini, included his analysis of the metadata, which confirms that no text message or images sent by either party were altered or otherwise fabricated. So that, we have a whole video on that. It is in the Maraschini playlist, as well as the Bachelor Unravels the Truth of Owens playlist, but it's probably easier to find it in the Maraschini one if you have not watched it. Number 7, any and all witnesses listed by petitioner subject to appropriate objection. Next, we have respondent's objection to petitioner's witness. Respondent objects to any and all petitioner's witness which have not been timely disclosed. Respondent specifically objects to the expert testimony of Dr. Medchill under Rules 702 and 703, Arizona Rules of Evidence, as he relied on an admittedly tampered with data set, made inappropriate conclusions regarding his beliefs unrelated to science, and appears to have concluded with zero scientific DNA basis. that Clayton was the father of twins. His testimony is not the product of reliable principles and methods or based on sufficient facts or data. In his opinion, does not reflect a reliable application of principles and methods to the facts of the case and should be precluded or given the weight it deserves. I don't see Judge Matta saying that Madchill can't testify. I think she's going to allow it because that's all that Owens has, so that she can say she had her fair shot. But, like I've said, we can't dislike Dr. Madchill. I mean, you can, obviously. But we have to remember that when it comes to Dr. Madchill, he is going based off the insufficient medical stuff he was given and fraudulent stuff. That is not his fault. His report and his findings may be different if he was given proper and real medical information and there was no fakery going on. But he wasn't given all the facts. So we have to take it with a grain of salt and remember that it is not his fault. That is on Owens and Gingras, who didn't give him everything that he needed to know to come to his conclusions. Now we're going to get to go over the exhibits. This is just a list. A lot of these we have gone over in all of these videos that we have done up to this point. So we've got the text from petitioner, re-unblocking, text between parties, re-blocking and meeting up, messages between the parties, LinkedIn messages between the parties dated May 17, 2023, text messages between the parties dated May 25th, 2023, emails between the parties dated 6/28/23, email from petitioner dated July 1st, 2023, emails between the parties dated September 17th, 2023, email from petitioner's sonogram dated October 14th, 2023. So there it is. It's an exhibit. David Gingras. There is that October sonogram that you say you have no clue about, which we know is a lie because we've shown it to you and we know that you watch things, because that's why you talk shit on the internet about us. Not about me. No, he doesn't include me in that. I'm not important enough for that. But when he's talking about Dave Neal and Megan Fox. Email from petitioner to respondent's father. Yep. She talked to the father. Email from petitioner re-ultrasound dated October 6, 2023. Text from petitioner re-unblocking. Email from petitioner re-going public. That's where she's threatening him to go public. She's going to go to the media. The article petitioner wrote, I am the anonymous woman in the Clayton Echard scandal. Here is my story dated September 22nd, 2023. Articles where petitioner spoke to the press. Article petitioner wrote, unveiling the unbearable, my battle against cyberbullying and online harassment. We have seen that article, and that is the one that her father was like, oh, I'm so proud of my little girl, and he published it on his Facebook. Come on, Dad, stop enabling this behavior. Petitioner's medical documents. Petitioner's email to Hope, re-respondent speaking dated August 3rd, 2023. That is the speaking engagement that Clayton was supposed to have about mental health. And Owens messaged them saying, I don't think you should have this person as a face to speak out for this because he doesn't care that I am suicidal and he doesn't care about my mental health. Yeah, she's done that. Emails from petitioner's mother to respondent. Email from petitioner threatening to sue dated September 21st, 2023. So the mom has messaged Clayton as well. It's just insane. The list is going to continue. Email from petitioner, read medical documents, text messages between petitioner and Greg Gillespie dated July 11th, 2021 through August 8th, through August 24th, 2021. Text messages between petitioner and Greg Gillespie re-ultrasound dated August 6th, 2021. Records produced by family planning associates in response to a HIPAA release. Yay! Okay, I haven't seen that one. But in Gillespie Part 2, I was wondering if they had a HIPAA release on this ultrasound. So they at least have that one. So yay! Okay, I'm excited for that because I want to see that. I haven't seen it. But I wonder if they ever saw her. My guess is no. Audio of Greg Gillespie and Laura Owens being pregnant with twins. Audio of Greg and Laura conversation, fabricated sonograms from August 2021. We went over and heard both of those recordings at once in the last Greg Gillespie video we've done. Petitioner's affidavit dated May 3rd, 2024. Petitioner's sonogram dated July 7th, 2023. Planned Parenthood response to follow-up letter dated April 26, 27? Okay, whatever. I think that's supposed to be 2024. Emails between respondent's attorney and Stormy Mitchell dated April 26, 2024. Petitioner's faking ultrasound. FTR for October. Part 1. FTR for October hearing Part 2. FTR for November hearing Part 1 and the FTR for November hearing Part 2. Records produced by Dr. Hunter and any lab tests now in response to a HIPAA release. That is in regards to the Greg Gillespie case. Records produced by Dr. McCool and Scottsdale Perinatal Associates in response to the HIPAA release. Records produced by Barrow Neurological Institute in response to the HIPAA release. That's where her epilepsy records and stuff are. Samantha Deans, MD, her expert report. Faye Elizabeth Justia Lindy, MD's expert report. Deans and Justia Lindy, MD, their curriculum vitae. Email to Steve Carbone. There's 2 of those dated April 24th, 2024 and April 29th, 2024. Email to Dave Neal dated 4/25/2024. Email from Michael Maraschini dated 4/26/2024, including medical records sent from Laura Owens in 2016. Twitter post from David Gingras. Berry Hill expert report dated May 7th, 2024. Berry Hill digital forensics report, selected text messages, petitioner's deposition, respondent's depositions, petitioner's counsel blog post, petitioner's email to the court dated August 1st, 2022, petitioner's counsel emails and tweets, emails between petitioner, current and former counsel, notice of intent to sue, email from petitioner, suicide dated September 21st, 2023, email from petition to Scottsdale Police dated July 31st, 2023, and lastly, medical records from Women's Care of Arizona, Dr. Higley. So those are the evidence that is going to be used in this June 10th hearing. Respondent and his counsel reserve the right to supplement this list of exhibits as necessary, so he can add or take away if he feels the need to. Respondent's objections to petitioner's exhibits. Respondent objects to petitioner's expert report under Rule 703, Arizona Rules of Evidence. Petitioner submitted admittedly falsified medical records to her expert for his review, including the sonogram that she has admitted to tampering and which has been confirmed not to have originated from Planned Parenthood or Smile and notably not included in the ovary removal she allegedly had in 2016, which she appears to be claiming she does not remember fabricating. Well, I mean, to Owens' credit, I mean, she has a lot of lies to remember, wouldn't it? Like, this is hard to keep 10 years of lies straight. You know, you don't remember all the falsehoods when your whole life is a lie. Her expert relied on fabricated data to reach his conclusion, which is not his fault. which itself is inadmissible under 702, meaning his written opinion is not based on those kinds of facts or data that experts in his field would reasonably rely on. And it is nothing against Dr. Medchill. It's just not. I wish Woodnick would say that, it's not his fault, but I hope Medchill doesn't take this personally, because he just doesn't have all the information. Respondent objects to any and all petitioner's exhibits which have not been timely disclosed. Respondent objects to any and all of petitioner's exhibits which have been doctored in any way, including those already admitted to being fabricated by petitioner and which were confirmed not to have originated from any source petitioner testified to being seen by. Respondent further objects to any petitioner's exhibit which are not relevant, cumulative, or lack foundation to these proceedings. Respondent is unable to prepare specific objections as petitioner has not disclosed her list of exhibits. Well, I don't think you did until now either, but maybe you have. It just wasn't done publicly. It says respectfully submitted 3rd day of June 2024 by Woodnick, and it was sent to all of the people that it needed to be sent to. And Clayton signed his verification under penalty of perjury that the, foregoing is true and correct of his knowledge and belief, and he knows them to be true. And he signed it on June 3rd, 2024 as well. So, our quote of the day, which I think works very well because we have an outline of all the lies over all the years and stuff. A summary outline, basically. Always tell the truth. That way you don't have to remember what you said. Mark Twain. Owens can't remember all of her lies. But if she would always tell the truth, she wouldn't have to remember. Clayton tells the truth, so he never has to remember what was said and what happened, because his story doesn't change. The facts are, the truth is what the truth is. But when you lie and you make up a bunch of stories, you have to try to remember all that. And you've been doing this for 10 years. There is no way to keep up with all of that unless you have it documented in a journal. And apparently you still don't, because you don't remember it, or you're just lying about not remembering it. I think you very much know that you did those things with Maraschini, and you're just like, oh, I don't remember. We're not buying the BS. You have ruined your own reputation. You have done this to yourself. Nobody else has done this to you. You have destroyed your own life. And you tried to take down not only victims, your exes, not only your victims, you have tried to take down any attorney you've had in the past. You've tried to take down Woodnick. You've tried to take down media. You've tried to take down Dave Neal. You have thrown, professional companies and doctors. You've brought them into this that have nothing to do with you. And hopefully their reputations aren't messed up. You have also drug people in that you've stolen sonograms for. The Vanishing Twins lady. You have a long hit list that you have affected. And none of these people deserved the hellfire that you put into their life. And you deserve to pay and have consequences, whatever those may be. Civil and criminal punishments. In my opinion, that is what you deserve. You are not a well woman. You need to seek help. And I don't know if you ever will. I don't know if you'll ever realize that, because you have been enabled your entire life. You act like a spoiled little brat who doesn't get their way. And you have ruined so many lives because of it. And it's unforgivable. The lies and the things that you've done. It's unforgivable. It really is. That's where we're ending it. Please like this video, hit subscribe, share it, comment your thoughts, turn the notification bells on so you know when the next one is coming. I am going to be doing Corey Keith's statement in another video, and then I will try my best to, I should be able to wrap up Greg Gillespie's series in at least probably 2 more videos, but all of it will be done by June 10th for the hearing. So yeah, but I will see you guys in the next video. Bye.